From time to time, the law has to catch up with advances in technology, and with cell phones now more like handheld computers, the Supreme Court heard arguments today on whether the information stored on a cell phone is protected by the Constitution. Here's Chief Legal Correspondent Jan Crawford.
The question before the court is whether police can automatically search through a cell phone when making an arrest, just as they would a billfold or a briefcase, or whether officers first need a warrant. The justices struggled to find the right approach, applying words written more than 200 years ago prohibiting unreasonable searches and seizures to new technology that makes personal information more readily available than the founders could ever have imagined. Said Justice Elena Kagan, people carry their entire lives on cell phones. That's the world we live in. More than 90% of American adults have a cell phone, and 58% have smartphones that essentially are like mini computers. The Obama administration argues that cell phones are fair game during an arrest. As Justice Antonin Scalia put it, our rule has been if you carry it on your person, you ought to know it is subject to seizure and examination. But Scalia indicated there should be some limits, saying it seems absurd for police to search a cell phone if they've stopped someone for a minor traffic violation, a concern echoed by Justice Anthony Kennedy. We're living in a new world. Someone arrested for a minor crime has their whole existence exposed on this little device.
Now, the justices also showed they were pretty savvy about technology. They were talking about Twitter and Facebook and whether police officers could put a cell phone on airplane mode. All of this, Scott, in a court that does not allow cameras or any recording device inside, not even cell phones.
And a decision on this expected in June. Jan, thanks very much.